Four cases caught my attention at the Supreme Court this year. The president terminated a member of the NLRB and a member of the Merit Systems Protection Board, and a district court said that was illegal because the statute says they can just be fired only for cause. The Supreme Court stepped in and put a stay on that order while the case bubbles up through the appellate court system. A heterosexual woman sued under Title VII, claiming she was discriminated against based on her gender identity. And a lot of courts had been saying that she would have to show special circumstances indicating that the employer was one of those strange creatures that discriminated against the majority. But the Supreme Court said, no, there's nothing in the Title VII that says anything about that. Every individual is entitled to the same rules of procedure in terms of pleading and in terms of proof. And a retiree sued, claiming she was discriminated against on the basis of her disability. But the Supreme Court said, no, she can't do that because she is not a qualified individual. And that is because she neither has a job nor desires to have a job. And in a Fair Labor Standards Act case, the employer was trying to show that an employee was exempt from the statute. And the question was, what kind of burden of proof does the employer have? And the Supreme Court said, well, they have the normal burden of proof to show by a preponderance of evidence. Thank you for watching.